Well, hello everyone. Welcome back to the Veteran Lang YouTube channel. If you've been here before, if this is your first time, hey, welcome. I'm so glad you found us. Always glad to have everybody here where we educate in VA disability with the sole purpose of one day in the future having this VA disability claims process so smooth between veterans and VA alike that perhaps you don't need your friendly accredited VA attorney Matthew Lang in the middle. Hey, I got another topic for you today. We're going to call it the reasonably raised claim. Going to be a shorter topic than we normally do, kind of straight to the point, a lot of examples, and a discussion on how veterans, you may be able to help in the process when filing the claim in VA, how not to forget to look for things that you're required to in the process just because it's not worded exactly. So we're going to get into that in a moment. Before we do, I want to take a second to still note that we are undergoing a government shutdown. There's definitely some stresses that are going on within the walls of the government. We also know that our VA employees here have been trapped in the middle of it all. I do want to reach out and let you know that VA, we think about you. We hope for a quick ending to all of this and a satisfactory ending for this shutdown so that if you're not getting paid, that you can get paid. If you're furloughed, that you can get returned back to work, and just be able to take care of yourself, your family, and enjoy life ultimately in the end. So, as we know, it's a stressful time. We do hope for the best, and just know VA and other federal employees out there that we do think about you and hope for a speedy result to this whole process. All right, here is the topic again: reasonably raised claim. So, in short, really quick, what that means, veterans, is that when you file a claim, the VA can't just look at what's written word for word on the paper and stop there. So they can't look at what's word for word on the paper, right? They have to do that. But they can't just stop there and say, well, that was the claim. Underneath the law were a series of court cases, the CFR, the United States Code. The VA has a duty, and they have a duty to fully and sympathetically develop your claim, veterans, to the highest possible level. Even if that means you did not use the exact medical terminology or legal theory when you filed your claim, veterans. So the courts have said over a number of years now, probably over decades, that VA must again give that sympathetic reading. You got to determine all potential claims raised by the evidence. The courts have also said that a claim for one mental health diagnosis actually includes any mental health diagnosis that's reasonably raised by the record. So again, just another showing of how what you write down on a piece of paper as one condition may be diagnosed as something else in the same family. Therefore, that has to be addressed. Now, we're going to talk about some of these examples here in a moment, but I want to get you an idea here, veterans, and just a refresher to the VA that these duty to assists, again, are out there based upon the courts. They've been there for decades. The CFR, the United States Code, tells you, VA, that you got to assist the veterans in developing their claims and to adjudicate all issues, again, reasonably raised. That's really the point here: adjudicating, developing, and assisting with all reasonably raised claims, whether that be a different diagnosis than what's written down or a different legal theory than what's written down. So let's take some examples. So we got this. So there's a few different ways we might find this. So let's start with this example here. So let's say, veterans, you file a claim for just knee pain. That's all you write, knee pain. So the VA is going to look at that, and they're going to have to determine what's knee pain. Now, they got the series of other duties that they've got to do underneath the duty to assist and so forth, and they will likely get there, but they're going to have to look at all the evidence before they do. Maybe even request VA examinations before they get there. So let's say you filed knee pain. It got interpreted as arthritis. So the VA looks at it and says, well, we don't see arthritis in service so it's denied. But what we do see, perhaps, in this scenario, is that the record shows a meniscus tear, maybe an instability of that knee, or even a secondary condition like back pain from altered gait. So those issues are all reasonably raised by the evidence in this example, and the VA has to consider them. So let me hash this out just a little bit more. The idea of veterans is if you write knee pain, not knowing what that diagnosis is, just knowing you have pain, and perhaps you've self-treated for years because, well, that's what we tend to do. Motrin, water, suck it up, drive on, right? The pain is just so unbearable now, it's time to go get help for it, and you seek out VA. You claim knee pain. Maybe you get to the point where a VA examination has occurred, the x-rays have come back and shows arthritis, so the VA examination shows diagnosis of arthritis. And the VA is going to go back and go, well, there's no documentation of arthritis in your service treatment records, so it's denied because it's not in service. Well, that's got a series of other errors to it, but bear with me. The idea here is that when you do go back into the record in this example and you find other things that could be related to that current diagnosis of arthritis, or maybe you have other diagnoses that just got missed and you still have because, well, it's not that the examiner didn't know, it's just they went off of what they seen when they did your exam and what's in front of them. So it could be possible that you have some instability in that knee shown in the records, veterans. It could be also possible, again, that secondary condition of the back pain. So all that's got to be addressed. We would have to look at the idea of is the arthritis still service connectable underneath what other diagnoses that are in the evidence. But we also have to look at that secondary theory too. So in this idea of the secondary theory, veterans and VA, the issue I'm using here is back pain. So let's say veteran is service connected for the back pain, and now they're claiming knee pain, but they never claimed secondary to back. Well, the evidence is showing in this example that the secondary condition is plausible and reasonably raised by the service connected back pain because there's a showing of an altered gait. We just know there's that connection after so many years. And we know the medical literature supports that. So because veteran, you didn't say secondary, doesn't mean the VA can just stop it direct. They would have to then address that secondary theory as well. So that's really how this works when we talk about the reasonably raised claim of everything here. Now let's see if we can give some other examples just really quick here. Let's say, veteran, you file a claim for breathing problems. You just find it hard to breathe. You're not sure what's causing it. It's just hard to breathe. For whichever reason, you haven't really sought medical attention to it yet or got treatment for it or diagnosis. You just know something doesn't feel right, and so you seek out a VA disability claim for having troubles breathing, and you just know you've had troubles maybe breathing for years now since service. Well, again, the evidence comes back and happens to show you have well, a diagnosis of COPD. But maybe for some reason, VA looked at the breathing problems and just made the assumption that you were claiming asthma. Because again, breathing problems is a really bad example here because it's very generalized. And ultimately, it should have probably, in my opinion, and experience, prompted some sort of phone call to clarify the condition. But sometimes this happens, though. It's taken as a different condition, taken as asthma. But the record showed you had COPD, but they denied asthma. So record also shows perhaps you had exposure to burn pits, but that was never addressed either because maybe the VA said, well, asthma wasn't documented in your service treatment records. So we have a few different things going on there. We have a different diagnosis from what you've labeled. What was presumed needs to be addressed because they are reasonably related. It's reasonably raised. The burn pits is a whole theory of service connection. If the evidence shows that that's what you were around, veterans. So again, it's just the theories and the actual diagnosis of themselves. VA must develop and adjudicate these when they're reasonably raised. If the VA doesn't adjudicate these when they're reasonably raised, by law, it is a duty to assist error and a reasons or bases error. Grounds for reversal of that decision is definitely set in place underneath an appeal, potential remand from the Board of Veterans Appeals, duty to assist error by a HLR, or just straight up reversal from a supplemental claim, perhaps. Now, veterans, this doesn't mean, though, underneath this rule, that you should rely on the VA to catch everything. It can't be missed. There's a lot to review. You should strive to always be as specific as you can when filing. That would be probably the best practice, I would say, from my experience. But again, this is your claim, your choice, and how you decide to work it, and with your representatives, how they guide you through the process and advise you. But I would say that myself, we strive to make sure it's as specific as possible when filing. Help the VA out, help the claim move smoother, because that's what we're here to do. We're here to help each other out to make it a smoother process. Now, sometimes it happens. It even happens to me. Maybe you file it one way and you realize that your condition should be filed or is connected in a different way. So like secondary to another service-connected disability. Now, don't assume you've got to start over, but maybe make note of that to the VA, or maybe your representative will. Help them find that theory. Now, you can argue that the VA should have already addressed it because the record raised it. Yes, and we will. That's what we do. But just know it's especially helpful in appeals when you're trying to preserve the effective dates to avoid the VA saying that's a new claim. Just try to be as clear as possible. So here's really the takeaways I have for you here. The bottom line is that the VA claims are not a game of gotcha. Veterans don't have to speak in perfect legal or medical terms. VA, they don't have to speak in perfect legal or medical terms. They're not lawyers. They're not doctors. Most of them. If the evidence, veterans, on your story points to another condition, diagnosis, or theory of service connection, well, VA must address that. That's their duty. And when they don't, well, that's where your representation or your accredited attorney like myself can make a difference. But at the same time, veterans, as a closing takeaway, is remember to do your best to claim the condition with the actual diagnosis and even potentially the theory of law, if you know it, just to help make it a smoother process. So, like I said, this is going to be a smaller video than probably most, but that's the main focus I wanted here is a reasonably raised claim. We do see it happen often enough for me to address it here. So, VA, just keep that in mind. We'll make the arguments. I've made a bunch of them today even about the reasonably raised claim issue. So, just throwing it out there. And veterans, like I said, it could be easier on, well, your representative, and the VA if you know exactly what that condition is and how it's diagnosed. You may not know what it is, and that's fine. We can work around that, but it may be helpful to claim it with the exact diagnosis. With that, everybody, thank you for being here on this terrific, tremendous Tuesday, which I haven't done that for a while. How much fun was that? I hope to see you again next Tuesday. As I cut out here, one thing I realized I forgot at the beginning of this video is by a request of a veteran, I have put much thought into the idea of running a live Q&A event. We're going to give it a shot. I've recruited some help with my lack of technical ability back here. We are aiming for Veterans Day this year, November 11th. We are planning on right now attempting 2 platforms, YouTube and TikTok, simultaneously live. So share with your friends. VA employees, you're welcome too. Always happy to answer your questions the best I can as well, because again, we're all here with the same mission to help the veterans and to hopefully make this a smoother process in the end. I'll see you next week.